All right. Well, good afternoon, everyone. I just wanted to say welcome to our webinar this afternoon. We are so glad you're here. My name is Missy Morgan. I am the Director of Marketing for Sante Consulting. And I just wanted to give you a few words about Sante, and then I'm going to turn it over to our next speaker. Sante is the national lab recruiting and consulting firm here in the United States. And we focus exclusively on the recruitment and retention of pathologists, PhD and doctoral candidates, and then lab executives. So I wanted to give you just a little bit of scoop on what's happening at Sante Consulting today. We're working really hard on a brand new website. Our URL is not going to change. It's still going to be santellc.com. But what is going to change is we're going to have all kinds of new tools and resources, a brand new user experience, and it's going to be a lot easier to navigate and find what you need when you need it. That'll be coming out in the next few weeks. And I hope that you're following us on both LinkedIn and Facebook. If you're not, I highly recommend it. We've been posting for candidates in lab medicine a tip of the week every week, just to help you along in your search, to make it more enjoyable, to relieve some stress, and to help you have the tools and resources that you need to get through it. So we have those things under our belt and coming up soon. We hope you stay tuned. And then what I'm going to do right now is turn it over to our founder and president, Rich Cornell. Now, Rich has been in the lab medicine recruiting and consulting industry for 31 years. He's got a wealth of knowledge, and he's really excited to be here today. And I also wanted to say one thing that I've noticed about Rich in the many months that I've been working with him is that he really does care about making that right match between the right candidate and the right job opportunity, so that everyone involved has a win. And it's really fun to be a part of something like that, and to watch him work that way, and the team that he has working at Sante. So without any further ado, what I'm going to do is turn it over to Rich.
Thanks, Missy, and welcome everybody. I want to take this opportunity to express my sincere gratitude to our speakers and attendees. It's nice to see the list of attendees for this webinar. It's a great mixture of residents, fellows, experienced pathologists nationally. You know, I reviewed the attendee list here recently and recognized many of the names and institutions, and have worked with many of you over the years. So it's nice to see everybody in attendance. You know, our firm, Sante Consulting, is committed to provide the highest quality recruitment services to pathologists, laboratories, pathology groups. We have entered our 14th year in business, and personally, you know, I'm dating myself, but it's my 32nd year within the industry. I'm proud to say we've found more jobs for pathologists over the years than any other third-party recruiting firm nationally. And I can say that's a great feeling to have, to help change so many people's lives by guiding them through their career paths. Today, we're here to discuss physician employment contract law, a great topic. I highly recommend to anyone who's seeking a job or a new position to seek legal advice before you enter into your employment agreement. I tell candidates all the time, make sure you use somebody that's familiar with physician employment contract law, and not just a family member or a friend who may be a general attorney. Our speakers today are from the nation's leading law firm that specializes in healthcare, McDonald Hopkins. I had a chance to meet our speakers at this last Executive War College in the fall in San Antonio, and they really impressed me. They had a team of attorneys from all over the country and had a major presence there, all of whom specialize in healthcare. Today, our speakers are Elizabeth Sullivan, and she's the chair of the National Healthcare Practice Group at McDonald Hopkins, and Emily Johnson, also a member of the National Healthcare Practice Group at McDonald Hopkins. Both have an extensive background and experience in working with pathologists, laboratory groups, commercial and private laboratories. So without further ado, I'm going to hand it over to our speakers, Liz and Emily. Thank you.
Thanks so much, Rich. I'm just going to share my screen here. Bear with me 1 second. Okay. I hope everybody can see my screen. So thanks again for having us here today. You know, we're really excited to have this opportunity to present today on this topic. We obviously, as lawyers, we find that the concept of a physician agreement to be a very important step in either the beginning of your career or, you know, some sort of transition moment in your career. And, you know, lawyers love contracts, but I think for the reasons that we're going to discuss here today, you might get some tips, or we hope that you'll get some tips regarding why these contracts are so important and why they should be evaluated by somebody who has experience in this area. So, you know, kicking us off, I am going to talk a little bit about the types of agreements and some considerations when starting down the path of entering into a new agreement. And then I will turn things over to Liz, and she will discuss some of the terms of the agreement. And then I will circle back with some considerations regarding professional malpractice coverage. And then we'll sort of close out with some ownership considerations and then some questions and answers. So with that being said, let's start talking about the types of agreements. So, you know, as I alluded to, the contract essentially defines the conditions of your employment or the engagement. You know, the relationship is usually a very positive one with whomever you're seeking to enter into an agreement with at the onset of the arrangement. You know, everything is rainbows and butterflies, but the contract, as lawyers, you know, we're trained to look and anticipate the worst case scenario. And that is one of the purposes of the agreement, right? So it will define your rights and responsibilities, but it will also dictate in many ways how you handle a dispute with your employer and what your options are with respect to termination or separation of the agreement if you were to leave to go elsewhere. Of course, salary is a very important consideration, but there are many other considerations that I believe are equally as important when assessing whether an employer is a right fit and assessing the terms of your contract. So, you know, with respect to the type of agreement itself, whether it's an employment agreement or an independent contractor agreement, of course, there are going to be healthcare regulatory considerations that your attorney should evaluate. You know, anytime there is some sort of compensation that relates to the performance of medical services, you want to consider your obligations under the federal anti-kickback statute and any state equivalents of the same. You know, under the anti-kickback statute, with respect to physician employment agreements, there's some pretty wide discretion on how physicians can be paid. You don't, unfortunately, have that same discretion under the Stark law. Now, Stark is only going to come into play if you are performing designated health services, which, as you know, pathologists, labs, you know, that is directly within the realm of the Stark law. And so when negotiating your contract, one of the things that will need to be assessed is whether the compensation that's going to be paid to you fits within the purview of the Stark law or an applicable exception. If instead of employment, you are seeking some sort of shareholder arrangement, this is different than an employment agreement. So an employment agreement, you likely don't have any equity in the company. A shareholder agreement gives you some sort of equity or a piece of ownership in the entity, and then typically results in some sort of sharing of the revenue. So again, there's going to be Stark law considerations and how that revenue can actually be shared. And then professional services agreements, we see these all the time with respect to pathologists. So it can be an independent contractor agreement. You know, you're going to perform pathology services on behalf of an existing group practice or on behalf of a hospital. And then certainly medical director services agreements. Those are typically when you are performing some sort of administrative services to the physician office, a hospital, or a laboratory that are, you know, related to the patient care services that those providers are offering their patients. But in all of these cases, you must document the arrangement in order to receive protection under both the anti-kickback statute as well as the Stark law. The concern of the government is that, you know, an arrangement could be viewed as a vehicle to provide some sort of compensation or remuneration is the word that they like to use to physicians in exchange for referrals of patients or medical services back to the group, and for which the group could then submit claims to Medicare or Medicaid or other payers. So it is very important that any agreement, meets those requirements of the AKS and the Stark Law. And, there are some distinctions among the two, but generally speaking, the agreement must be written. There must be a description of the services that are to be performed. It must be commercially reasonable, even if there were no referrals flowing between the groups. And then the compensation must be carefully structured, like I noted. It must be, the buzzword that we like to use is fair market value. So it must be fair market value. If we're talking like a medical director agreement, generally speaking, for that type of compensation, it's going to be hourly. But for an employment agreement, there's different options on how you can structure that. So again, having somebody who knows the ins and outs of how to structure a physician employment agreement in accordance with the applicable exceptions to Stark and AKS is going to be really, really important. Again, touching on sort of the distinction quickly, and I'm not a tax person, I'm a healthcare attorney, but it's important to have your accountant involved in some of these discussions, particularly if you are going to be engaged as an independent contractor. When you're an independent contractor, generally speaking, you're not offered the same types of benefits, and you're usually responsible for paying your income taxes. And so that's usually, means you have to set up some sort of quarterly payments. And if you don't make those payments quarterly and you make them at year end, there can be some sort of financial penalty assessed against you. I believe the penalty can be fairly nominal, but it's still a penalty nonetheless. And so you're going to want to meet with an accountant or somebody who has experience in structuring those types of tax payments so that you can stay ahead of that and not experience any of those penalties.
And I would just add, Emily, just very quickly, even on the shareholder agreement side, like depending on if somebody has an opportunity to buy in, we have some slides at the end about ownership opportunities, but that's another place where there are potentially tax consequences that aren't going to be immediately apparent unless you're working with, accountants, counsel, that sort of thing. So that's important as well, because that can be a surprise on the back end.
Yeah, no, I think that's a really great point, Liz. And there's this concept, which I am not even going to begin to speak to, but this concept of deferred compensation that folks who are experienced in tax and executive compensation can certainly help you navigate. Let's see here, trying to advance my slides. Okay, so the first thing you want to do, so, now we know we're anticipating entering into some sort of contract. The first step is to identify the type of practice you want to work for and the location in which you want to work. You can reach out to recruiters for this, or you can work with teachers or alumni from your medical school or family to identify potential opportunities. But the best place to start is, listing the pros and cons of each type of practice and what you're hoping to glean from the arrangement and what your preferred opportunity is. In the group practice setting, you can have a pathology group like we referenced, some sort of specialty group like a GI group or a derm group, another specialist that's looking to onboard a pathologist. And then of course there are, multi-specialty groups. There's also institutional employers. So this would be, your healthcare system, hospital, or academic medical center, and then of course a clinical laboratory. There are distinctions in the types of decision-making power you will have at each of these types of employers. And so, if independence and independent decision-making is something that you desire, then perhaps a smaller practice or a solo practice is more up your alley and what you're looking for. Also, if you have the ability to get some sort of shareholder agreement so that you can be a part of the decision making, that is a consideration here as well. But on the flip side, when you enter into that type of arrangement where you are a shareholder or part of a smaller group, you can have additional overhead expenses, financial expenses, so it can be a little bit more expensive. In the hospital side, in the academic medical setting, you of course are going to have a little bit less say with respect to decision making, because you're going to be subject to the hospital's bylaws and their rules and regulations and their policies. But you will have less financial expenses. So typically they'll cover, your malpractice insurance and some of your continuing medical education requirements and things like that. So there's definitely pros and cons to both, which is why I always recommend starting with some sort of pros and cons list. Again, when negotiating the contract, and I think we'll talk about this throughout the presentation, but one of the critical things is going to be, what is your leverage with respect to your negotiating power? And at a smaller group practice, you might have a little bit more leverage to get the things that you want. Whereas in a hospital or institutional setting, a larger setting, it might be more of a take it or leave it situation. And so you want to be mindful of that as well.
Yeah. So Emily, that's a perfect point. I was just going to emphasize that I think when you're going into these sorts of negotiations, having an expectation of what's going to be reasonable in the negotiation is exactly what Emily said. With a group practice, maybe even a clinical lab, depending on the size of it, you might have more leverage. But with a large institution, typically they are very focused on keeping everything consistent. And so, what you may be doing as far as reviewing the contract is going through it to understand what's in there, to make sure there's nothing that's sort of a deal breaker from your perspective or something you need to be careful of. Like, we're going to talk more about termination and things of that nature, but you may not be able to make as many changes. And so being able to understand that at the outset is really helpful, just to kind of set your expectations and then also to work with your advisors. So good point, Emily.
Great point. Thank you, Liz. Okay, so, I did mention compensation, but when you're assessing the employer, there's two things you want to look at beyond salary and compensation. And the first is going to be a non-economic appraisal of the entity. So, this is going to be culture and benefits and things that you hope to get out of it from a personal aspect. And then on the next slide, we'll talk about some of the economic considerations that you want to assess as you navigate this process. But, with respect to the non-economic appraisal, our recommendation is always to meet the owners or the decision makers and any other employed physicians or staff to get a feel for the practice. What is the culture like? How do those folks work together? One of the really critical things that we're seeing as attorneys, even when people, want to work with us, the question is, what does your diversity and inclusion look like? And that is a really critical issue right now. And I think it's an important question to ask. If it's something you're passionate about, what is the practice doing to foster diversity and inclusion, and, getting a better feel of that. If you have the opportunity to observe practice operations, that's always a great idea. Jumping in and shadowing somebody for a day is a really great way to get a feeling of what the group looks like and how they work together. Another question worth asking or looking into is what the nature and the strength of the leadership team looks like. So, who are those decision makers? If you're not going to be a part of that team, what sort of things are important to them, right? So what do they want their practice to look like in 2 years, 5 years, 10 years? What are they hoping to turn it into? What opportunity do you have to join that leadership team and to have a say, even if you're not a shareholder? Another great question is, how long have these folks been in charge? And is there an appetite for change if change is warranted? All of those questions can help you sort of get a feel for how the practice functions on a day-to-day basis. And of course, the reputation and status in the professional community is important. Who are they? What is their goal in the community? Is there a charitable component of what they do? Are they well known for one particular area? Are there opportunities for growth as well? Moving on, success and historic experience with new members. So what do their retention rates look like? And this might not be an easy question to ask of leadership, but it might be something if you have an opportunity to speak with other employed physicians or contracted physicians, or even office staff members if you're looking at a physician practice as opposed to like hospital. Find out, how long are folks sticking around, because that can be a clear indicator of what the culture is like. And if you're starting to talk with folks and everybody's been there for a really long time, that can tell you, they have some sort of vested interest in the practice and they are at least looking to stay. Everybody's always interested in learning about, what the part-time policies are, particularly if you have some sort of flexible arrangement or contemplating some sort of maternity leave. What does leave look like generally, whether it's maternity or short-term disability, or I shouldn't say maternity, I should say paternity. And what those retirement policies look like if you stay with the firm or with the medical practice. So, if you were to retire there, is there some sort of post-retirement benefits? Are they going to cover, some of your tail insurance requirements, if that's, the type of insurance that you're going to be required to carry? And so, framing those discussions early so you know what it looks like later on down the road is important. Of course, location features is important. You're going to live where you're practicing. So what does the community have to offer you? What are the schools like if you have children? Where are the places of worship if that is something that's important to you? What is the surrounding area, and what things are available for you to do for fun and your recreational time? Another factor here, which kind of comes into the economic appraisal as well, but you have to consider the cost of living wherever you're going to move, because that is going to sort of dovetail into the compensation considerations as well. And then of course, transportation needs, whether you're driving or taking public transportation. Succession planning, you can talk about that when you're just vetting leadership, but what does that look like when people step down? How is that process handled? And what does that mean for the practice as a whole? And then quality of life issues. I mean, I think all of these kind of relate to quality of life issues, but certainly, what are the hours expected of you to work? What is the vacation policy? What benefits and opportunities are available to you, whether it's mental health awareness or just health and wellness in general, or other quality of life considerations that are important to you. And then of course, the economic appraisal of the entity. This is vetting the financial status of the entity. So how long have they been in business? Ask questions about what their expenses are, what their revenues are. Do they carry any debt? All of those questions are going to give you a feel for how stable the practice is. Certainly in an institutional setting, I think there's more of an understanding that it might be a little bit more stable. I mean, depending on the institution and what's going on, but so a healthcare setting, healthcare system setting or institutional setting, they might be less inclined to provide some of this information, but I think it becomes critically important if you're thinking of joining a group practice. Obviously discuss compensation and benefits for different physician levels. So what does your compensation look like as an incoming physician? What does it look like 5 years down the road? What does it look like if you transition into a shareholder, and do your benefits change at any point? On the last slide, I kind of discussed what the room for growth is, but find out what their ancillary businesses are now and what their plans are down the road. That shows you the growth potential, and it also shows you kind of the appetite for leadership and what they're willing to do to further develop revenue for the practice. Another great question is getting an understanding for their payer relationships. So what % of the revenue comes from Medicare versus private pay versus self-pay, and how reliant they are on specific payers. If there's one payer contract that's really important, that makes up a big chunk of the business, that could create some vulnerability in the event that rates decrease or if you lose the contract. So certainly a consideration. And same thing with the hospital relationships. If the group is wholly, if you're looking to join a physician group and they're wholly linked to one hospital, that also can create some vulnerability in the event that the relationship turns sour, the hospital goes with another pathology group. So definitely a question worth raising or a consideration to keep in mind. And then of course, referral relationships are important. is the group part of an IPA or a physician health organization that creates some sort of referral relationship among other providers that essentially sets rates? If that's the case, ask what those rates are. Are they competitive? Are there compliance concerns related to those rates? You know, all of these questions can also play a factor in the event the practice was ever going to sell. You know, Liz and I have seen this come up in the context of a deal, and this conversation might be premature now, but certainly if you're a shareholder and at some point a decision is made to sell the practice, if there's any issues with how these things are structured, or if you're, I guess I should say, even if you're looking to start your own group right now, if there's an issue with how these things are structured and you go to sell, it can actually impact the valuation of a deal. So certainly important to get it right on the front end. And then, you know, this last bullet kind of ties into the question regarding payer relationships, but what does the patient population look like? Is there a high percentage of Medicare or Medicaid? Is there a high percentage of uninsured patients? How is the practice handling uninsured patients or any financial constraints of patients? Getting a better feel for the answers to these questions can help you appropriately vet the entity a little bit more. Okay, so Rich actually touched on this a little bit at the beginning, and I couldn't echo what he said more, but don't be discouraged from using legal counsel. And to Rich's point, you know, don't just use a real estate attorney or your cousin who used to be a prosecutor. You want somebody who has specific experience in negotiating employment contracts and somebody who has some knowledge in the healthcare space. You know, you're not just contracting for the salary. Like I said, you're contracting for your rights and your responsibilities, and also your remedies in the event of a dispute. A big question that we get all the time is it worth it to pay for an attorney to take a look at my contract? And as an attorney, right, I'm going to give you the self-serving answer of yes, but it's not because I'm an attorney and I want the work. It's because, you know, pay for the review of your contract now. It might be a couple $1,000s, but it is critical to get it right now instead of, you know, having a dispute down the road and then having to spend 5 times the amount in legal fees, if not more, resolving some sort of dispute. So, you know, it might seem sort of, you know, harmonious and great up front, and you're just so excited to start working and you want to just sign that contract. But I mean, I've seen this with some of my friends. Take a step back, have somebody look at the contract. I know it slows it down a little bit, but you'll feel so much better in the long run knowing that you did that. You know, interview more than one lawyer and get names of reputable lawyers in this field from whomever you can. Medical schools are a great resource for this. They have you know, folks that they can refer you to that have helped other alumni in this space as well. And then when you're engaging your lawyer, you know, discuss the payment terms. How much is it going to cost? Am I going to be billed on an hourly basis? Is there some sort of retainer? Could we do this as a flat fee? Most lawyers have flexibility in how they structure their engagements, so I think it's worth having that discussion up front. And then in the engagement discussions, you know, set the deliverables you want from your lawyer. Do you want them to be fully involved and responsible for handling the negotiation? Do you want them just to take a high-level overview of your contract because, you know, it's a hospital contract and there might not be much you can do, but you still want to meet with them to understand the terms of the contract? You know, set those boundaries up front. And set them clearly in the engagement letter that you sign. The engagement letter is sort of how you cloak everything in attorney-client privilege. So make sure you get one of those as well. And, you know, make sure that your dialogue with your attorney is clear and concise about what you want. You know, at the end of the day, you're engaging this person, this expert, to perform these services for you to negotiate your contract, but you're going to be the one who has the contract after it's signed. And so you want to make sure you understand the terms. So don't hesitate to, you know, to ask questions. What does this clause mean? I don't understand this, because it's important that you do. You know, we kind of talked about this a little bit, but on the other side, you know, you want to determine who has the authority to negotiate the contract on behalf of the employer. So it might be you or your lawyer interfacing with that person, but is that person their legal counsel? If so, you probably want to have them talk to your lawyer as opposed to through you. Or is that person, a shareholder or other physician at the practice? You can all be a part of the discussion. You can have both legal teams on the call, but make sure the key decision makers are part of those discussions. Particularly in the health institution setting, the academic medical center, the hospital setting, ask for some of the relevant materials early, copies of the bylaws or any policies and procedures you might be subject to. Because lots of times, and we see it, the contract is going to incorporate by reference the hospital's bylaws. And if you don't have those, if you don't have a copy of them, then you don't really know what you're agreeing to. So make sure you have a copy of them. It's going to outline any appeal rights you have with respect to any administrative actions that might be taken against you. And we'll just, it's just good practice to get a copy of those up front. Certainly establish a timetable to negotiate and finalize the contract so you don't run out of time. But like I said on the last slide, take time to consider and discuss the contract terms so that you do understand what you are agreeing to. This is just more of a reason to, negotiate or engage legal counsel. Again, your agreement will establish the foundation for your employment and it will set the rules. The negotiation process is certainly a two-way street, but the discussion is something that, in my experience is usually fairly respectful. It's not usually very adverse. It can be, but it's usually not, right? The parties are excited to work together and they're just trying to protect their best interests. If you are raising some sort of negotiation and you think that it is something that has negative implications for you, if the language isn't changed, feel free to raise that. This language, if we change it to state ABC instead of XYZ, it's more favorable for both of us because there are regulatory considerations if we phrase it the other way. So point those things out. And then, if anything is ambiguous or if something's missing, make sure that you get those terms defined. I think that's the benefit, particularly if you're negotiating contract and they have a lawyer on the other side, there might be some legalese in there that can just be confusing, maddening, seems circular, can be misleading. And so really understanding the terms and what they mean is going to be important. And then, like I said, don't be afraid to ask for reasonable changes. And don't be afraid to ask, what does this contract look like if I do, evolve into a shareholder, or if I want to retire, what are my future options? And are those things that we want to add to the contract now? And then I'm going to turn it over to Liz. She's going to talk about some of the terms of the contract.
Right. Thanks, Emily. Okay, so we wanted to talk a little bit about the terms in a little bit more detail. So this just says, what are the characteristics of a good employment agreement? It's clear and consistent. Emily has already alluded to this. Sometimes forms get used for a long time. And here we're talking more about if you're negotiating with a practice and a smaller organization. With a larger organization, for all the reasons that Emily outlined, you're more understanding what's in there, but you're not necessarily going to be in a position to change it. Clear and consistent. Sometimes with practices, the agreement might be years old. There might be language that's bolted on. So it's a good idea to make sure that, whatever's on the piece of paper, it's clear and you can sort of understand what the intent is and what it means. Balanced. So these documents are going to be drafted to the benefit of the employer. That's just, it's sort of nature that they're going to be drafted that way because they're going to be prepared by the employer. However, that doesn't mean they can't be fair. So that's part of the process. If you're using an attorney, they can help you navigate that, but it's reasonable to ask for, something that's fair. Comprehensive, and we'll get into this as we go into some of the terms. You could have something that is very short, right? It has really basic high-level statements about the term, the length of the agreement, the compensation, the benefits, but how do those things actually work? That's really what the function of the contract is. So your salary, when is it paid? What happens if the agreement terminates? How are benefits accrued? Those sorts of things need to be in the document, or they need to be in a policy that you've seen. for you to really have some comfort that you understand how it's going to work. And then reflective of business requirements, Emily talked about this at the beginning, with physician agreements, because of the possibility of referral or direction of business that might be reimbursed by a payer or by a government program, it's important to be able to hit those marks. So that's also where an attorney can help you. Next slide, please, Emily. Thank you. We're sharing Emily's screen today. So key provisions, parties, that's obvious, but let's make sure they're on there. Do you know who you're negotiating with? Do you know who you're actually going to be employed by? If it's a larger organization, or even within a group, if they have multiple entities, that's important. We don't have to spend too much more time on that. And then we'll kind of get into these on other slides. The duties, coverage, obligations, and support, term and termination, compensation and benefits, obviously important. Liability insurance is important because it's so expensive. So whose responsibility is it and when? Restrictive covenants, can you continue to practice depending on how you might end your relationship? And ownership opportunities. Next slide, please. So to get into a little bit more detail, duties and coverage obligations, sometimes contracts are really vague about what your responsibilities are. If you have a lot of trust or you understand how the organization operates, that might be okay. It sort of depends on the circumstance. But what you'd really like to see, or what we'd like to see, are sort of specific days and hours of expectations, or at least how many hours a week, what are on-call expectations, where do you have to maintain privileges if you have to maintain privileges, what types of organizational meetings are mandatory, what might you cover for the group, at facilities, that sort of thing. What are the requirements as far as licensure and certification? If you're coming from a different state, you have a different license or state license. Does a group want you to maintain it? Do they not care? Is that your responsibility? Are they going to take that on? And then outside activities, what are you able to do outside of the group if you want to do that? And another point here is if you're negotiating with a private practice, and that private practice has contracts with hospitals and health systems, make sure you understand what non-competes or restrictive covenants the group is beholden to under its professional services agreement, because as a physician, you are going to be essentially required to agree to those to be able to join the practice. So that's kind of another level. And we do have some slides about restrictive covenants coming up. And then practice location, Emily alluded to this. If there are multiple locations, make sure you understand where you're going to be covering, because you probably want that in the agreement. If there are locations that you don't want to cover or tough to get to on the other side of a city, you want to make sure that's in there, because if it's not in there, then it's the type of thing that might get shuffled around. And maybe it has to anyway, in certain circumstances, but as much comfort as you can have, all the better. Next slide, please. So compensation, I kind of alluded to this earlier, and I think Emily did as well in the introduction. What is the frequency of payment? So for a more organized, or for an employment agreement, it's probably going to be, every other week, it's going to be monthly, it's going to be consistent, it's going to be reasonable. If you're entering into a situation where you are going to become a shareholder or have some ownership, make sure you understand how the shareholders are compensated, because they might give you numbers, but it might be based on distributions, it might be something along those lines. So it's important to understand that and make sure that you have that in the contract. And that is going to be different based on what type of arrangement you're negotiating. Is it a straight salary? Is there a bonus opportunity? Is it a salary that's based on a formula? And is that based on individual productivity? Is it based on, the organization's collections? Are there quality measures? Quality measures often come in more frequently, in an institutional structure. And that can be good or bad, because if they're ambiguous or confusing, that can create, extra stress at the end of a given year or quarter or whatever it may be. So make sure that you understand those as well. Formulaic compensation structures, if it's in a group practice, they might also allocate expenses or overhead. So make sure you understand that. And we actually have this in here as a practical tip. Get an example of the formula. Even if it's not in the agreement, if you can get an example of it, that will really help, illustrate how it's going to work. And sometimes that's important, because you can be talking about it and, the person delivering it to you is seeing it one way as they're saying the words. You may be interpreting it or envisioning it a different way. So it can be really important to do that. Some of the other things, is there extra compensation for call coverage, or is that expected of you? Are there ancillary services? Like if you're not going to be at a pathology group, but you're going to be at some other type of provider specialty, how does that factor in? Where do you fit into that model? Supervision or collaboration with non-physician providers. Again, that's, depending on the type of organization you're with. And, are there pieces and parts of this that are sort of knit together? Next slide, please, Emily. Thanks. So as far as other considerations with respect to compensation, is there a stipend before you start? For what it's worth, for foreign nationals, until a visa is approved, that cannot be paid. Depending on a circumstance, if you have a unique circumstance, you might also want somebody who has an immigration background that can help with that. It really just depends on what your circumstance is, which is why, as Rich alluded to at the beginning, it's really important to bring counsel in. And again, to Emily's point, it's not necessarily to say, hey, we're here talking to you, we're the counsel for you. It's finding counsel that's appropriate for what your needs are, depending on the circumstance. Understand a signing bonus versus a retention bonus. Signing bonus, what are the terms of that? You basically get that if you're signing on and you're showing up for day one. Retention bonus, you're going to have to stay for a period of time. How long? What happens if the agreement is terminated before you get to that point? Are you entitled to it under certain circumstances? What if it wasn't your decision to terminate the relationship? Is there an annual bonus? We talked about this a little bit. Recruitment incentives, depending on if you're going to a new location, any sort of moving expenses. Is there an income guarantee for the first year? We talked a little bit about signing bonuses, that sort of thing. When and how is compensation, revised? So we'll talk about this a little bit with terms and auto renewals, but does it get revised frequently? Are people set for a couple years? How does the organization make those determinations? That's important to know up front. And then rights to offset. Oftentimes an agreement will talk about when an employer might be able to withhold some of your compensation, whether it's, for expenses in the instance of a particular type of termination, if the termination is not on good terms, those sorts of things. So understand if there are any sort of financial implications from there. Next slide, please. This is fairly straightforward. So, and Emily talked about some of these things. Make sure these things are either in the agreement, or if they're not in the agreement, then you've seen the policy that governs it. And if they are in the agreement, then keep in mind that those are pretty much locked in, unless there's a negotiation of the agreement or an amendment, or if the agreement says that it can be sort of changed unilaterally by your employer. If it's in a policy, then make sure you understand how that policy can be updated, because sometimes that policy can be updated annually. So this might be a moving target. So make sure you understand that and how it fits in to the terms of your agreement. Next slide, please. And I am trying to move a little bit just to make sure that we have time for questions at the end. So if people have questions, we hope to get to them. And so, even if you have questions after this, if we move quickly through a slide or a particular topic, please feel free to reach out to us. We're happy to answer questions. So some of the other things that might be part of your benefits: covering credentialing, covering licensing fees, professional organization fees, all these other sorts of things. Just understand what's part of your package. What are the benefits? And if some of these things are being covered, when might it be your responsibility to pay the group back if you guys, terminate, or if the arrangement, I should say, is terminated, without cause, or, just unilaterally by one party or the other. Next slide, please. So as far as the term, this is important because, it's probably going to be a 2-year term, a 3-year term, a 5-year term. But you want to understand if there is a without cause termination provision, because that essentially tells you how long, or really what the length of the contract is. So is it possible for one party, either yourself or the employer, to terminate the agreement on a certain amount of notice, 90 days, 60 days, 120 days? If that's the case, of course, the intent of the parties at the outset is for the agreement to run the full term. But if it's, what it really means is functionally or practically, the agreement could be terminated on that shorter period of time. So that's important to understand. And we don't actually talk about it in this slide, but the other thing you want to understand is what types of cause allow your employer to terminate for cause, because a without cause may not come with any sort of financial consequences. It may not impact your compensation or your benefit structure, anything like that. A for cause termination might impact some of those things. So you really want to understand what type of rights does the employer have to terminate? And the same thing is true on your end. What ability do you have to get out of the agreement? Most of the other things I think are fairly self-explanatory here, so I'll keep moving if we can. So next slide, please. Again, these are the things that we sort of talked about before. Most agreements are also going to have termination provisions that relate to disability or death. So it's important to focus. I mean, both of those are very unfortunate, but disability is probably more of a place to focus for a negotiation, because you want to understand what is considered disability, who is making the determination about disability, that sort of thing. Next slide, please. Okay, so effective termination. This is also fairly self-explanatory. It's kind of what I alluded to before. If termination happens for cause, it may impact some of these things. It may even impact some of these things if it's without cause. So make sure that you and your advisors are sort of matching those things up so you understand what the implications of termination may be. Next slide, Emily. Oh, and I guess I'm turning it over to Emily now to talk a little bit about malpractice, because that obviously is a very big expense if that's something that falls on you individually. So it's really important to understand how that fits into the compensation as well.
Thanks,
I'm
Liz.
sorry, to the agreement as well.
No worries. So we're just going to touch briefly on the malpractice coverage, but one of the things you want to explore during the contract negotiation process is who's going to pay for the malpractice coverage. Generally speaking, if you're a W-2, your employer typically pays for it, but it's going to depend on the type of coverage you need. So there's coverage for prior acts and omissions, coverage for acts and omissions, tail coverage, and then there's this concept of outside or other activities. Liz touched on moonlighting. I discussed medical director activities and clinical research, but finding out what the responsibilities are with respect to the policy is going to be important. If you are an employee, like I said, your employer typically is going to cover the cost, but it will only be during the term of your employment, unless you can get your employer to agree for tail coverage if it's required. If you're an independent contractor, generally speaking, you will be required to pay for your own insurance costs. So that is another factor when evaluating the financial considerations of any offer you receive. And then, if you have, and we'll talk about this on the next slide, but if you have claims made insurance coverage, you will need some sort of tail coverage that provides coverage after you leave the practice. And you might be able to use this as a negotiation point to try and get the employer to cover some of the costs of that tail coverage if your employment is terminated without cause. So if you didn't have a say in it, it might be an option to get them to cover some of those costs, or at least a portion of it. And then with respect to what's covered, it's important to check with the broker. Typically, insurance policies are limited to the work that you do for that particular employer, and any outside acts would not be within the scope of coverage. So if you are doing some sort of moonlighting or any additional professional services unrelated to your scope of employment with this particular employer, you might need to carry some sort of secondary insurance for these activities. As far as liability limits, some states actually set the amount of limits, or at least the minimum limit requirements. So it's important to check with state law, but generally speaking, we see limits that are on average of, $1 million per claim or $3 million in the annual aggregate. Also worth noting, higher risk specialties or surgical specialties typically will need more coverage than that. The type of coverage you need on day one kind of depends on whether you're, a new employee starting out, or if you had any previous insurance with a prior employer. So definitely be mindful of that. If you're sort of in a transition phase between employers, check what your existing coverage is, what your tail coverage is, and then ask what the coverage looks like with the new employer. But I threw out the term claims-made insurance. So there's typically two types of insurance. There's claims-made and occurrence-based. Occurrence-based essentially covers any claim for an event that took place during the period of coverage, even if the claim is filed after the policy has lapsed. So this is typically significantly more expensive than claims-made insurance. And so for that reason, it's less frequently offered. But the good thing with respect to occurrence-based insurance is that you don't need tail coverage. So you won't need any insurance once you leave the practice, because you'll be covered under the occurrence-based policy for any misconduct or acts or omissions that happened during your employment. And then claims-made insurance, this is the more frequently offered type of insurance. So this type of insurance only covers the situation if the claim, or only covers the claim if the policy is in effect both when the incident took place and when the claim is filed. So again, your claims-made policy, if you leave your employer, is generally going to terminate. You're going to be removed from the employer's policy. And so that's when you need some sort of tail coverage. If tail coverage isn't offered as part of the claims-made policy, it usually can be separately purchased. And like I said on the last slide, it may be covered by a prior employer or the new employer as a benefit or incentive to join the practice. This is just a quick overview. So like I said, tails policy covers prior acts or omissions after you leave your job or the insurance policy terminates. It's only needed if you have claims-made insurance, but it also comes into play for retiring physicians. So if you have, a claims-made policy and you retire, you're still going to need some sort of tail coverage to protect you from services that you performed while you were employed. So you may no longer be practicing, but you're going to still need that coverage. The cost of tail insurance can be expensive, but it generally can be about 2.3 times the amount of the annual premium. So if an annual premium is $2,000, the estimated cost of a tail policy is going to be $4,600. And then, things worth asking is, if the employer is going to cover your tail coverage, is it going to be with the same insurance company? And then another consideration when vetting a new employer, if you're going to switch employers, is the insurance carrier the same? Because that can prevent gaps in coverage, and it can be a more seamless transition between jobs. And then this is just a quick overview, just an example. I won't go into much because I want to leave time for questions, but this is a scenario of like when insurance would be triggered and when you would have coverage. So definitely recommend spending some time on this if you have specific questions about insurance. But in the interest of time, I think I'll probably kick it over to Liz. I just want to note one thing. I think it's worth reiterating. So if the employer provides claims-made insurance, make sure that the contract is clear that you are not required to pay tail coverage premiums if the employer terminates your employment without cause or you terminate for cause. Those are conditions in which the employer should be obligated to pay for your tail coverage. And I will kick it over to Liz to talk about restrictive covenants.
Yeah, no, that's such a good point, Emily. So, again, we're not going to dive into these because of our timing, but from a non-compete perspective, a couple high-level things to consider. You might see a non-compete, a non-solicitation or non-interference. A non-compete is personal to you as the physician, and it's going to be based on a particular scope and for a particular period of time. And you should always just consider when you're signing this that it's something that can be enforced. Like, don't try to think, okay, in my state, this isn't enforceable, because it's it's going to be expensive to fight that out, even if you're right. So kind of operate from that perspective. Non-solicitation means, you're not pulling other employees or staff members, and non-interference is not interfering with sort of business relationships. So those are things to keep in mind. We do see those in a lot of contracts, and the landscape for restrictive covenants continues to evolve. So that's definitely a piece that you would be tackling with your advisors. And then, Emily, if you don't mind just going to indemnification for 1 second. We have a slide on indemnification. This is typically what you're going to see with independent contractor agreements. You may have to indemnify or agree to some sort of indemnification. It's basically just a contractual thing saying, hey, I'm willing to take on the risk in these circumstances. Typically, you shouldn't see indemnification clauses in an employment agreement. That's not typical for an employment agreement, and our labor and employment attorneys would say that shouldn't be in there. But, keep that in mind. On the independent contractor side, professional services agreements, you may see indemnification. And then finally, we have some slides on ownership opportunities. We're going to stop here so we can take some questions. I know we've only got 5 minutes left in the hour, and we're happy to stay a little bit longer as well. But there's some information that you should consider if you're potentially evaluating an ownership opportunity. And if that's part of the partnership track that you're joining, make sure you are thinking about that on the front end, and that you understand and that there are clear metrics and obligations on the part of the group to actually move that along at the outset. So that's certainly, if we're talking about a freestanding employment agreement versus, partnership opportunities, that is also, something to consider about bringing in advisors and how much you sort of want to invest in time and resources and things of that nature with the negotiation. So with that, we're gonna stop, and we are certainly open to any questions on anything that we covered or didn't get to in our slides. I'm happy to take questions now.